All right, we're prepared now to resume and continue with this process of looking at conditions. The next set of conditions to which Wynn has objected are on page 18, and they all have to do, conditions 1, 2, 3, 4, continuing over, 5, community fund payment, water transportation payment, 6, coming down to 6 on page 21, all have to do with the specifics of and payment of and these annual payments that we've discussed now several times. And I think that trying to go through these line by line with the numbers in this forum under these circumstances would inevitably lead to errors, mistakes, and probably we wouldn't be finished till Thursday. So what I think it would be helpful to do is have a general discussion on whether we are prepared to accept the response that we currently have or accept it with modifications and have the staff incorporate the picture into a set of the formal conditions that we'll send back, that we'll adopt, and will be the final resolution of this part of the process. Anybody disagree with that approach?
No.
Okay. So who wants to start the discussion of whether to accept basically the response as fortified by today's, or not necessarily fortified by today's, but in light of today's comments?
I can begin.
Okay.
Well, I, for one, I am pleased to see the transportation reduction, the plan we put in place back on the table. It does have a cap, but I don't believe a cap is unreasonable in this particular case. The look back is more narrowly tailored, but I think that will be inclusive of what we were looking for here as well. And this was never about dollar amounts. It was about the right amount of skin in the game with regard to short-term, long-term mitigation. We've been back and forth a couple of times now, and I am, I think that we've accomplished the goals that we set out to here with regard to this mitigation in Sullivan Square. I'm happy to see the examples of the traffic reduction plan here, a number of examples of ways to achieve that, and that's an important piece here. So that's a piece I think is important as well.
All right, other comments?
I also appreciated the inclusion of the addition back into the inclusion of the look-back provisions. I think for us as a commission going forward, thinking about use of the Community Mitigation Fund, it would be helpful to have those studies in place in all communities, just so we have an idea of what we might be mitigating in the future. So the inclusion back into the look-back conditions I thought was very helpful.
Yeah, but the look-back conditions are different from our look-back conditions. The
Yes.
look-back conditions are basically reopener provisions that allow reopening of the framework upon the occurrence of various statutory conditions, rather than the kind of study that was going to be a regular feature of this, regime on a going forward basis. So they're two different things. Does that make a difference to you, or?
No, it doesn't.
It does not. Okay. Commissioner Zuniga?
I'm also very pleased, as Commissioner Cameron says. I, for one, understand the ranges and specific payments better. I understand the notion of the cap. I think it does provide the overall framework here, as presented today, provides a certainty of sorts. Maybe that's not a very good sentence, but provides a lot more confidence to the applicant, but also to the city. I would argue that if there are, like we understand, there may be federal funding sources that could complement this effort, or other sources that could eventually complement this effort for the long-term solution, that is. Having a stream of, having a number that is built by multiple numbers, of course. There's upfront payments and there's annual payments, but having an actual, an estimate, not a wide range, and I understood why we needed that original framework of the range. So I think that it provides a lot more certainty to the city, to the applicant, of course, and to us, to everybody involved. This, I would imagine, is what the result of an arbitration could have yielded, and I think we've made a lot of progress. I would ask, I would ask the deadline notion.
Can we put
Can we
that to
come
one
back to that?
side for a second?
Okay.
I'd like to deal with that
Separately?
separately. Yeah, I was just trying to get through the terms of the. So the Sullivan Square piece of this is now a total of potentially $51 million with the transportation demand management incentives. They're referred to as fines someplace. They're not designed to be fines. They're designed to incentivize thoughtful approaches to a dense urban site that depends heavily on large numbers of patrons. So 51 million, it's hard to figure out exactly what the right number is. It's on the low end of our range. But have you thought about that? I mean, our range was inflated above that by the example we used, and the example sort of came from nowhere, except it didn't. It looks like it came from nowhere. It picked a 200-car excess over the projected number of cars that would use the Sullivan Square intersection. And the projection was based on an actual analysis of the number of cars that would go through there at a peak hour. That number, the base number, didn't come out of nowhere. And the 200 cars was above that base number. The long-term solution to Sullivan Square is a solution based not on accommodating more traffic, but on reducing the overall vehicle flow. So the likelihood is that the long-term solution, and this is what the Metropolitan Area Planning Commission said, and the Boston Transportation Department said, and others have said, the long-term solution is likely to lower that base number on which we base the hypothetical. And so a 200-car excess from that lower number is not unreasonable to expect. We didn't just pick the 200 out of nowhere. And so it seems to me that if there's to be a cap, and I can understand why there would want to be a cap. I don't think it makes any sense for any business organization to get into an uncapped obligation. I'm not sure how you could deal with that on the financials. That it ought to be closer to the 40 million than it is to the 20 million. Because I don't think that in the last analysis, once one gets to the final solution, the 40 million is going to be as hypothetical as it may be now.
Let me understand what you're saying. I thought that the 200 car excess was during and prior to the long-term solution. Once there's a long-term solution, there's already been a solution.
Right. But the long-term solution inevitably, I mean, the short-term solution is inevitably going to if people are thoughtful, and we have to presume that they are, inevitably going to take account of what's ultimately planned. And so the long-term solution may not accommodate the numbers of cars that we're talking about right now.
But I thought I thought that was part of the condition. As long as the long-term solution accommodated the casino traffic, all of these payments would flow. If the city does not design to that, if the city or all the stakeholders do not design to the long-term solution, then there is really not a long-term solution, right?
That's right. But all I'm suggesting is the possibility that when the final permits are issued, and they haven't been, and when the final MEPA process is finished, and when the final design is considered, it will be a design that's different from this design, that will be designed to interface with the long-term solution, which one would hope that it would, that there is some planning that goes on that affects that, and therefore the numbers that we're using as the base number may be lower, even though they're numbers for the temporary solution.
I don't understand how those numbers could be lower.
Because there simply are numbers, and they're based on the plans that currently exist.
Well, if there's less traffic going through Sullivan Squares because those numbers turn out to be lower.
If the plan is for less traffic, the plan may not be realized by the actuality.
But I think it is important to when we put this plan together, we did say a plan that would accommodate casino traffic.
Right.
So if another plan is selected, I don't think this applicant should be responsible for that, frankly. I thought that was an important piece that we put in place, was if the solution is a solution that does accommodate casino traffic.
Whatever traffic the casino wants to put in there? This is designed.
Well, but no, I think each phase of this mitigation is, we talk about the fact that the mitigation, the reduction is important. And I think the applicant has said that they agree, and there are a number of possible ways to reduce that traffic here listed. So I was encouraged to see that.
Well, I was encouraged to see it too. Now, I'm just talking about what a realistic cap ought to be on, and I agree with the concept of a cap. I understand that, but I'm trying to think through and talk through what a realistic cap should be, and I'm afraid that the $20 million is too low, because I think that the hypothetical that we provided and used as a basis is likely to either come true and more likely to morph into a number that's used for permitting that is lower than our hypothetical base number in order to accommodate the long-term plan. And that the permits will be issued based on an understanding of total traffic demand, of which the traffic generated by the casino is a lower number.
But how much more likely is that to happen, that there's an upside as opposed to also a downside on the way I'm thinking about it, and this is perhaps oversimplifying, the range that was put together thoughtfully, understanding that the variability could flow either way.
Exactly.
Not only to the upside, but also to the downside, because there are other mechanisms in place. The way I'm thinking about it, if we're measuring the number of cars that go through Sullivan Square during 1 hour, and there's a total standstill, right? Just to take, if nobody can get through there, there's a self-governing notion to these, right? There's not an upside that's infinite.
No, I understand that. I understand. And if there's gridlock there, then
if there's gridlock, then
going to be unhappy.
Well, but there's that number is not increasing ad infinitum because, well, nobody's getting anywhere.
No, and I'm not suggesting it should that they should pay for an ad infinitum increase. I'm simply trying to think through what the appropriate range ought to be. And if everything works out the way the permitting goes, the payments under this section will be zero, right? And so the question is, how much risk of that are we prepared to take? And the tender is, well, take $20 million as an incentive that will solve the problem, and incentivize us to solve the problem, and incentivize us to work toward a solution. That's much better than the position we were in the other day. $20 million, even over 10 years, is a big number. And I get that. My question is whether or not it's big enough to truly incentivize really creative thinking about how to reduce demand without interfering with operations.
Doesn't this also tie to another provision that we just discussed relative to the city or WIN petitioning to reopen this notion? Couldn't in the scenario that you're describing, couldn't that provision be used towards, if we did not anticipate, if the 200 number turned out to be grossly understated for whatever reason, couldn't that be a scenario where these get re-examined?
Yes, I suppose it could, but it's hard to re-examine. It's hard to re-examine in that context. Well, maybe it could. Maybe it could. We can't fully plan for what the contingencies are. The 51 million is a substantial number, and maybe that's the appropriate number. I take it the three of you think it is.
Because there are so many hypotheticals, it's difficult for for anyone to come up with a number that is realistic. So I'm comfortable because of that piece of this.
But it is possible to come up with a range that's broad enough to encompass all but the extraordinarily unlikely. And I guess all I'm saying is I don't think this range is big enough to do that. And your response to that, if I understand you, Commissioner, is to say, well, if it isn't, then petition to reopen. The city can petition to reopen.
Yeah, that's in a nutshell. I mean, I keep thinking of, we're all drivers, so we can all be traffic armchair experts, right? There is an adjustment, at least in theory, that drivers may make on certain times because they know how difficult intersections may be at different periods of time or the day. For example, the way I think about this, I never go shopping on Black Friday because I don't like, traffic, and crowds. There's some people who clearly do. And so there is at least at least an element of if the ramp is backed up all the way to 93, I might take the next exit if I'm going to Everett or so there. You know, there is some variability to the estimate. It is everybody's best estimate, and it's on very thoughtful. I think there's been a lot of analysis, obviously, by both our consultants, the applicant.
Okay.
Anyway, I'm going to.
Okay,
Stop there.
I understand the position. I think we're beginning to repeat ourselves, and I don't think I'm going to make any headway, and that's fine. We have a disagreement over that one, and I'm content to let that go forward with that number in place. Is there any other aspect of this that we need to think about? And I'm talking really now about conditions 1 through 1 through 6.
I just had a quick question. I think one of the original conditions that Commissioner Cameron put forward was not only solve for what MIPA tells you to solve for, but some resolution of traffic issues on the eastern side of Sullivan Square. And from your look at these numbers, even though it's not addressed specifically, do you feel that is being considered?
Well, in discussing this with, our traffic people, they believe in all likelihood MIPA will address this issue. So there's not an exact science here as to what will be done and what won't be done.
But that's an important point. I don't want to come back and revisit the number issue because I feel where everybody is. But there's an important piece to understand there. The MIPA is a mitigation discussion. Have you considered everything a process? MIPA doesn't issue any permits. Mm-hmm. The Department of Transportation issues some, but for these roads, the Public Improvement Commission, I think PIC of Boston, is responsible for and oversees these roads and will be the permit issuing authority for much of the work in and around Sullivan Square. So the fact that the project hasn't yet gotten through the MIPA process simply means that it hasn't gotten through the sort of omnibus approval process. It still has to get through and be approved by entities within the city of Boston, as well as perhaps MassDOT if it impacts the highways that the Charlestown roads can connect with. So, but in either event, it's the permitting number that's approved for the traffic through Sullivan Square, which in all likelihood will be a Boston number. Mm-hmm. So Boston has a continuing stake in this. Okay. So I take it that for conditions 1 through Section 3, conditions 1 through 6, we're content. Mm-hmm. The escalation piece really is simply designed and modified to accommodate the change in the packaging of the mitigation payments. I don't see any problem with that. Does anybody see any problem with that?
Nope.
The business development change, is the change there on page 8, condition 8, page 22, condition 8, is to make the obligation to spend $15 million effective on the opening date, not the effective date. In other words, it's post-construction purchases, not construction-related purchases. Was that the way this was intended? Or was it intended to get construction purchases?
I think this is spending for ongoing operational goods and services.
All right, so that change is acceptable? All right. On page 23, condition 9, the request was to hold, the condition was to hold at least one event, one event for involving employment opportunities, one event every 6 months prior to opening, and then one event annually for workers thereafter. And the response was they'd hold one event for each. I'm committed to the one event periodically. The place is going to be in business for 15 years, and it seems to me periodically that there's no harm in asking them to reach out to hold an event that advertises jobs and how you get the job.
And this is what we've done for the other licensees?
This
No,
language
this is-
comes from their BAFO. So
Right,
this was what was in their best and final,
Yeah,
and we
that's
took
right.
it straight out of that.
Right.
And I think I know the first piece of it is consistent with their other surrounding community.
Yes, and we made the change to the every 6 months, that was ours. But the balance of the language was from their best and final.
Right. All right, content with leaving this the annually and every 6 months in there? Okay.
Sure.
The next one is the look-back studies. Now, this is on page 24, number 11, the look-back studies. This is, we've talked about this briefly. The look-back study that they're talking about is the statutory look-back study. This look-back study is different. Are we content with the statutory look-back?
I actually had a question with that. Is it a statutory or regulations?
I don't remember.
The reopener provisions are regulation-based primarily.
That's right.
Yes,
Right.
under number
Well, we-
127,
Yeah, we
the
do.
statutory triggers.
Right, we do have reopener provisions there, and.
For surrounding community, actually, for all host
For all
and surrounding
host and
communities, right?
surrounding.
Agreements,
Yes.
right.
Among them, that the two parties petition, for example, is one
Right.
trigger.
Right,
That's an easy one.
right.
Yeah.
So what do we mean by the reopener? Not in the by the look back, not in the context of a reopener.
The concept is that twice, I think, at the end of one and
We did a construction
Twice.
period, first year, and 5-year.
Yeah.
yeah, there would be a analysis of certain impacts on the city, see whether unanticipated impacts had occurred, and if they had, and were traceable to the operation of the casino, then Wynn would be required to pay to cover them if more police were needed, say, than was anticipated.
Now, when we talk about the statutory one, are we referring to the research project that we're doing?
No, no, we're talking about how to reopen an agreement that's been signed.
So
Host
it's a,
community or surrounding community agreement. What kinds of conditions will trigger the ability of one side or the other to reopen and renegotiate that agreement?
right.
And this is a different concept. This is built into the license to allow, permit, and require a periodic look at what's actually happening on the ground and see whether the payments that were set up to deal with potential contingencies are actually doing so, or whether there's a shortfall that needs to be made up, and if so, by how much. That's what this is designed to do.
So is this redundant with the reopener that we discussed earlier?
Well, it's more specific.
Or is it not the one that?
No, I suppose you could use the petition
The petition
process to reopen, but this is built in anticipation of actually taking a look what's happening on the ground. It's in a number of surrounding community agreements, and I don't know if it's in, it is in several host community agreements as well.
It's in some. This one
Right.
is modeled on some of the agreements out of West Springfield and Longmeadow.
Right.
Wynn does have a look-back provision in their Malden agreement that is different from this. And both of them are different than the statutory. Sort of the statutory triggers are sort of the floor. Many applicants and licensees went beyond that in their host and surrounding community agreements.
Okay.
So is it conceivable that the applicant would be doing a study on regional impacts, not just say those for Malden, and could study the area?
No, it says here, our condition says, if at, when, at its expense, will conduct a look-back study by an independent third party to analyze any significant adverse impact experienced by the city of Boston caused by, and then there's a list of factors. And if there are significant adverse impacts that are not covered by, that cannot be mitigated by the payment they've agreed to make, then they will pay for those unanticipated adverse impacts. That's what the condition does. And
Yes.
it affects only the city of Boston.
Now, I know other reopeners or other look-back provisions, like in the statute, does weigh that with the positive impacts, don't they?
In certain host community and surrounding community agreements, I believe they do. They net them out. They've done that by agreement.
Right. Could we insert something that recognizes that there may be a positive impact?
Well, and I think we did hear, about some of these things would not be applicable because it would be open. So, construction noise really wouldn't apply. So there are pieces of this that really don't apply to a look back that starts after the opening of the facility.
Yes, and there's water, sewer, stormwater impacts.
Typically
is,
host.
Is not really applicable. Construction
Right.
noise is not really applicable. It's really public safety, traffic, with the exception of Rutherford Avenue and Sullivan Square, and that can't be mitigated by the payments they're already making. This is all over and above the payments that they're already making, and impacts on a park that's at the corner of the bridge and Sullivan Square.
But that's construction, right, around the park?
No, gaming establishment-related construction or traffic impacts at Ryan Park. So we need to we need to think about whether we want to do this or whether we're content to rely on the regulatory reopener or the petition.
I would be fine with the reopener here, since most of it is not applicable.
Okay, is that your position?
Same here.
Your position, Commissioner?
okay with that,
All
yeah.
right. Then there is I would prefer the other, but I hear where you are. The next one is page 26, condition 12. Which is a $250,000 cap on out-of-pocket expenses incurred by Boston for legal, financial, and other professional services as the cost of determining the impact of a proposed gaming establishment on the city of Boston, and in particular on Charlestown. $250,000 cap is what's being proposed.
Is this for expenses that may have been incurred in the negotiation and arbitration to arrive to a point like today?
Yes, that was the thought. They had a reimbursement provision in their BAFO, and that's where this language comes from. So I read it to include everything that Boston has gone through to date.
It strikes me that that number has to be higher, to be fair. But I put that out for discussion. It seems to, go ahead.
With some kind of a cap, though.
Yes, no, I understand the cap piece, but it seems to me that it has to be higher. And I'll leave it to the commission, I'll leave it to the staff to recommend what that number should be. Well, no, I don't want, we're acting in real time now, aren't we?
We are.
So I would, based on just the legal pieces of this and recognizing a lot of things, but recognizing the complexity of all of this, it seems to me that something in the vicinity of $750,000 is more reasonable than this is. So that's the number that I'd propose.
And you're thinking that captures already incurred expenses as well as anything else going forward, or you think we've hit a stop as to incurring additional expenses for the city of Lewiston?
Well, I think this reads as up to now. I mean, I think that's the impact of this once we issue this license. Is that how you read this? Or is this ongoing?
I think we would need to clarify what happens if they, in fact, if they went forward and negotiated a surrounding community agreement, they would deal with that issue on their
Right,
own, in their
right,
agreement.
Right,
So I would read this as being up to now, up to
Right.
the date of the issuance.
right.
And what would be
No.
the mechanism moving forward?
Well, moving forward, if they negotiated an agreement or they came to some agreement on those expenses, they would deal with it between themselves. Otherwise, going forward, there would not be any reimbursement for expenses after the date of the license.
Don't we have a mechanism for voluntary and involuntary disbursements where these could be helpful?
The involuntary, I'm sorry.
Yeah, I think part of if you look at our regulations, I think that process is designed to work during the application process and not after someone's been granted a license. So I would tentatively say that process would not apply after the grant of a license here.
Right. Now, we've also, in the past, honed in on the reasonable piece of these.
It's still
I
there.
remember it's still there. So it's understood that there would be a standard of evaluation
Well,
by somebody.
It's implied there, but we can add it if that makes you feel more comfortable. It's always implied in these kinds of things. For the reasonable, actual documented, no.
It does say reasonable.
It
It
is
says
in there.
reasonable.
Yeah, it
It says
says
reasonable.
reasonable.
And documented, which is
Right.
important. I think that the number you proposed would be acceptable, considering just all of the issues surrounding the city.
This has been a long and lengthy process. I think that frankly is on the short side, but I'm content to put that forward. And I recognize issues, but I think that's a much fairer and closer to the number that is, all
I'll go along with that.
right?
I'll
Okay,
go along with that as well.
$750,000 for number 12. Now, that takes us to page 27. Now, the Sullivan Square Infrastructure Fund piece is the one I mentioned yesterday that we are to be the escrow agents for. And the city is under this response to come to us with invoices. We're to determine if the invoices should be paid and then pay them. I really don't think we need to be in that position. So I would have the payments made directly to Boston to be held in a fund.
I would agree. This gets back to...
Or paid into a fund upon which Boston could draw for that purpose.
For that purpose, right?
Yeah, this gets back to our conversation about there needs to be a relationship here. And
Right.
It's a place to start, right there.
Right.
Did the applicant mention anything in their presentation? I forget,
Yes,
I was going back.
they mentioned that either or, whatever we
I'll go.
decided.
Yep,
Right.
then I'm fine with that.
Okay, now, conditions 2 and 3 are superseded by the omnibus plan that was agreed upon a minute ago, and can be inserted in the appropriate portions can be inserted in the conditions. Is that right?
I believe that's true of condition 2. Condition 3 is the incentive payment plan, so that language would remain the same, we would just cap it.
I'm sorry, that's
At the-
right.
at the
That's right.
amount.
That language, 3, the language remains the same, and it's capped at 20 million. All right. The escrow account, that's the piece that has us approving the invoices, and I'm not prepared to accept that, so that's condition 4 on page 29. So we take that language out.
Yes.
Everybody agree to that?
Yes.
Transportation demand management is,
Well, you're taking it out, I'm sorry, you're taking it all out because there's language here that is helpful if it goes to the city.
no, taking out the, if requested by the city and approved by the commission, funds in the SSIF may be applied to costs.
Oh,
Yeah.
you're saying
We leave the condition
leave the condition as
we
is,
propose
as we
it.
propose it.
Right. Sorry, I should have been more precise. Transportation demand management, this too is essentially been superseded by the other formula, has it not?
In order to have the mitigation plan, we'll have to look to see if some of that is required. We have to have the measurement plan.
Yes, that's right. This has to be tailored to fit now the overall approach taken in the condition response. And I think we ought to leave it to staff to tailor it so that the pieces fit harmoniously.
If I can ask the commission a question on number 4, in terms of the escrow fund, we did have language in there that said if construction didn't commence within a certain amount of time, the funds went back to the applicant.
Right.
And I believe that in their response, that language was left in there. So will we leave that language in there?
Well,
Wasn't it changed, the amount of years from?
it's changed by the effective date.
By the effective date, yes.
Yeah, and we're not accepting that change to the effective date. So if we reject the change to because that's got the DOR
DOR
piece in
date
it.
in it, yes.
And, well, no, wait a minute. It is changed because it is the effective date.
It's from the effective date
And
as
it
opposed
was
to the
from
opening date.
So it cuts back 3 years.
Cuts 3 years off it.
That's a good catch, thank you. I'd prefer to leave it the way we had it. So it's if construction isn't started 10 years from now, then they get the right to get the money back, as opposed to 7 years.
Fine.
So it would be 10 years from the effective date or 10 years from the opening date.
10 years from the effective date. I'm sorry, from the opening
Opening
date.
date,
That's
okay.
what the change, the effective date.
That was the original intention, right, Commissioner, of the?
Right.
It was, yes.
Sure.
Okay, so we've dealt with 5. You're going to tailor that, and General Counsel Blue. Number 6, the number of spaces. That was a condition that gave the commission the power to, although they built a garage of whatever size they wanted to, say they could only use certain spaces in that garage for customer parking. The intent was to further incentivize them to reduce vehicular traffic. It seems to me, however, on rethinking it, that is something we may not have the expertise to wade into. They have rejected that, and they're probably right. We probably don't have the expertise to get involved in that. So I would be content to have that taken out.
Yeah,
Does
I agree.
everybody agree?
Yes.
Same. Yep.
All right. The next one, page 31, amendment of traffic mitigation conditions. Is a reservation of rights to change things. Again, I think that that is part of the risk capping. And I think that I'm content to take this out and rely on the general modification, petition to modify conditions piece that appears earlier in the overall conditions.
Yep.
I think that's a better way to do it, rather than give us a unilateral right to just change things without even talking to them.
Right.
This is a sensitive kind of thing, and I think we need to consult and talk with them before we change it, once we get past this stage. Everybody agree to that?
Yes.
Yep.
Okay. Public page 32, condition 9, public involvement plan for hazardous materials. Their response, as it has been in other situations, is we'll obey the law. This required more outreach and a more aggressive, this condition did. But that's the response.
Yeah, and I think they've agreed to provide information to, say,
Right.
and then the process would be that they'd have to request, so.
That's what the regulations require. So this
Yeah.
was a condition that required them to do more than the regulations required in terms of outreach. Try and get the ball rolling and try and get things going. And they say we'll comply with the law. The law is there. The law is carefully crafted. And I'm not prepared to impose on them a condition that really requires them to engage in a spirit that would be very hard to police if they didn't. I mean, it's one of these conditions that'd be very hard to enforce. The requirements of law are there and are capable of enforcement. So I'm content to accept that response.
Yeah.
And then failure to
I'll go
obtain,
along.
I'm sorry.
Yep, I'll go along with that.
Failure to obtain required permits from the city of Boston, and we required as modified obtaining the permits by July 1, 2015. I understand the problem with that. On the other hand, the commission can't write blank checks and have unknown plans sitting out there without realization, without being able to take a different tack. Thoughts on that one?
You know, I think we have to, hope anyway that all parties will use good faith and come to the table and be serious about this. So if those are in effect within 90 days, they've been applied for, and I actually think it was unreasonable. I understand why we did it, and I agreed with it, other than, you know, if it doesn't happen by July 1, it would seem to me revoking a license is not an outcome that we want to be engaged in over something like this.
Well, maybe it does go to the overall risk assessment, and
It does.
so I'm content to take that out, but I'm going to come back to that later. Commissioner Zuniga?
Well, I do get the point of what they can control. And
Right.
just like we did we cannot promise something that we cannot control, like a statement from DOR. We can call them up, of course, and we've had those conversations, but it's not something that we can ultimately control. I understand their position on saying, hold us accountable to what we control, which is submitting the permits by some date, with everything that might be required before or after on an ongoing process. So I understand their position.
Okay, I take it we're content with that change, and that brings us to page 33, which is the last page, by the way. And there are a number of changes on there that they've made. I don't see any, I'm content with all of them.
I just have a slight edit to number 3. And again, we acknowledge that this was something in the act, but not in our statute, regarding the hiring preference of Suffolk Downs employees. I think we had also included MGC approval of a training and recruitment plan as part of that license condition.
To train and recruit Suffolk Downs employees? Okay,
Offer the hiring preference with a training and recruitment plan to be approved by us.
all right.
So it's somewhat different than what the act calls for. But I think that was in my original language of a license condition.
I think that's right. So we'll add, what we'll do is we'll take that and say hiring preference with a training and recruitment plan approved by the commission.
But is that a new condition that we're imposing at this point?
We did not have that language in this draft of it.
Right.
So it could be construed as a new condition at this point.
Well, let's go back and look at, if it wasn't in a document that was shared, that was certainly my
Okay.
intention. But if it didn't convey itself through the document to the applicant to consider that.
Well, let's put it in. It is different, but let's put it in and adjust if it's necessary. All right, so that finishes the list of conditions. It took longer than I thought, but there just is no way around that. We can't talk about these things in other forum other than this one, and it's really important to have now the Commission's expectations on the table, because at this point, these are final. This is not another chapter of negotiation. This is it. So if we award a license, we expect the conditions that we've just described to apply, and the conditions will apply, and we have reached a take it or leave it stage. I think it's fair to say. All the commissioners in agreement with that?
Yes.
Yes.
So there should be no misunderstanding about what we've just done. And for that reason, it was important to take the time that it has taken to work our way through these. General Counsel Blue's team will reduce those to writing. There may be some wordsmithing that has to be done, but the wordsmithing is not concept smithing. It is wordsmithing. And so that is the overriding approach that we'll expect to be taken.
It now occurs to me that when I discussed the conditions of Mohegan, we didn't go through a process like we just did, but I essentially talked about the spirit of the conditions that I imposed. I guess we were all in agreement, I suppose. You didn't.
Well,
We all didn't coalesce around it.
The reason we did this for the WIN application was that there were far more. The reason we
Yep.
spent the time was that there were far more conditions and there were far more changes. The Mohegan Sun application didn't have as many conditions because it was done against the backdrop of a surrounding community agreement, and there were far fewer objections that we had to deal with. In this one, we only dealt with the conditions with respect to which there was an objection, and we didn't deal with every condition. So
Yeah, no,
the two are
very
dealt
different.
with.
Yes, no, the only, maybe I'm just putting a very fine point here. We did not, to my recollection, all agree by consensus that all of the conditions for Mohegan Sun were accepted as presented. Did we?
Yes, we did.
We did?
And if we
Okay.
didn't, we should do it again.
Okay.
That is.
Then there it is.
We
by
effectively did it
consensus,
again.
We did.
Okay.
I believe
We
that
did
you
it.
did, but doing it again is
Yeah.
fine.
All right.
All right. No, we did.
It's good to have help.
All right. All right. Now, we've been at this for a considerable period of time. And so I think the next item on the agenda ought to be, is there another topic that we haven't discussed thus far that we need to discuss, apart from beginning the more focused evaluation? And if there is, let's talk about it now and deal with it. And if there's not, let's figure out what the next step will be.
You
I
first,
would-
Commissioner?
I wanted to go back and revisit, because I didn't think I thoughtfully answered the questions that were posed yesterday with respect to some of the construction labor figures, as well as some of the employment figures surrounding racing. One of the things that was not included in my original presentation slides was a figure which may have helped us understand the construction employment a little bit easier, and that was total amount of salary and labor income in construction. Again, these were numbers that were provided to us by each of the applicants. And when we originally put up the projections, we came up with a different amount of full-year equivalent salary. So what we worked on to try to balance out those numbers for everybody's benefit was to take, again, the two construction labor figures that were provided to us by the applicants. Mohegan Sun, Massachusetts had given us a figure of $293.7 million. We decided to go with a common figure as opposed to the 74,000 or the 114,000, but we used a similar FYE number, divided the labor income by the 74,000 for each, divide that by the 30-month construction period, multiply it by 12 to give us a year-long total, and it came back with 1,579 full-year equivalent jobs. For Wynn, Massachusetts, the construction labor figure they gave us, and again, all these costs that they have given us have all been triangulated back to the financials that they've also provided us. That figure was $621 million in labor costs, construction labor costs. Again, dividing it by the 74,000 full-year equivalent, divided by 36 months, which is their construction period, again, multiplied by 12 to give you a yearly total, and we came back with a figure of 2,797 full-year equivalent jobs.
What was that, 2,000?
2,797 full-year equivalent jobs. And again, you know, full-year equivalent is something different in construction trades because that involves everybody from the wide variety of trades in calculating that number.
So that's the apples to apples that,
That's the apples to apples. I gathered, Commissioner, you
yes.
saw the 74,000 number and 114,000 number, so we did the math using a $74,000 number for each applicant's
Okay,
labor figures.
thank you, that's helpful.
So the 293 million for Mohegan, on construction costs, that's a subset of their overall construction which I take to be about 400 million. It's 376 million in hard costs of eligible costs and other furnitures, fixtures, and equipment. Did we check on the ratio of labor to overall construction cost?
We didn't balance it out. Again, this is numbers that they provided directly to us.
Okay.
To address, again, the question of, I believe it was Commissioner Cameron's question about racing employment figures. We went back, we looked at a report that has been shared with us from Christensen Capital, direct employees, and this is direct employees, and this is both a full-time and part-time count, came up with, and I believe it was, this is the figure that was in the memo, was the total of 1,133 direct employees, does not include induced employment, but 1,133 direct employees with a payroll of $42,815,000. The total employment...
Can you
Go
repeat
ahead.
that again? I'm sorry.
1,133 full-time and part-time direct employees, and total payroll was $42,815,000.
42 million for Suffolk Downs?
This is for thoroughbred racing. The thoroughbred racing, I mean, that includes breeding ownership positions, racing positions. That's all
Okay.
total direct employment in thoroughbred racing. We took those numbers and added them to projected full-time and part-time employment for Mohegan Sun, Massachusetts. So we take that 1,133, we add it to the full-time and part-time count, again provided to us by the applicants, 3,172, for total full-time and part-time employment of 4,305. We add the two payrolls together, we come up with a figure of 142 million for a combined payroll between Mohegan Sun, Massachusetts and racing. On the other side of the ledger, obviously, without racing is Wynn, Massachusetts, which has, again, provided us a total of full-time employment of full-time and part-time employment of 4,382 jobs with a payroll of 170 million. There was some additional information also in that Christian Capital report, which projected some potential future increases in racing and labor for the year 2019. So we just kind of took those numbers again as well. We used full-time employment, part-time employment, again, same numbers for both applicants, but when you looked at, again, projected racing employees, that number went from 1,133 up to 3,086, and the projected payroll, again, in this report, was calculated out at 64,982,000. So if we took just to give you a feel in this 2019 snapshot, taking the projected increases in racing employees together with Mohegan Sun, Massachusetts, again, the flat current full-time, part-time employment, the total number of full-time and part-time jobs in racing would be, racing in the casino would be 6,258 full-time and part-time jobs, a total of 164 million in payroll. And again, on the other side of the ledger, Wynn, Massachusetts, again, using that full-time, part-time number they initially supplied us of 4,382 full and part-time jobs, and still 170 million in payroll. So more jobs, again, projected out in this report through 2019 between racing in the casino operations of 6,258 jobs. The payroll, again, on a projection, would be 6 million below the estimated original payroll for Wynn, Massachusetts.
All right,
Sorry for all those facts and figures.
No,
but I
that's
wanted to
that's
clear that up
good
from
information. More information is good, and that's helpful, so thank you. Is there any discussion of that? Commissioner Zuniga?
Yeah, the payroll numbers for racing, I'd like to understand them better. I'm familiar with the financials for Suffolk Downs, and because they present them as a racing employee, and the numbers are smaller than that, but lower than that. But I'd like to understand if that's a memo that you have. I'd like to.
I'd be happy to call our consultant down front, too. We can answer these questions hopefully together. Lyle?
I think
If
because
that's
it's a combined, those are just not numbers from the staff at Suffolk Downs. Those are
Right.
combined numbers,
It's,
racing from the industry, which would then give you the larger number for
Which
for payroll.
are paid or supported by purses, for example?
What do you mean, where does the money come from?
Yes.
For the industry? Yeah, I
Right.
think all of those, it would,
All of those are paid for by purses.
well,
all of the
some of
sources.
them, some of the ones that are directly related to those race owners, breeders, yeah,
Right,
that's correct.
okay.
But that's the overall the overall result, albeit without all that detail that you gave the other day, is the result that still obtains with the detail, right?
Yes.
Commissioners, probably just very quickly to clarify, the Christensen Capital Report identified 1,133 direct jobs and $42.8 million in labor income for the entire statewide thoroughbred racing industry, which includes breeding, ownership, attendees at the racing events, and the racetrack itself. The Suffolk Downs component, or the racing component, was subcategorized as providing about 300 jobs and $28.6 million in payroll.
Okay, does that help?
That helps.
Good.
Thank you.
Okay, thank you very much. All right, is there anything further, Commissioner Stebbins, that you want to update us on? All right, that's good. Commissioner Zuniga, any further subjects you want to talk about?
Just a little bit from yesterday. Will we continue this conversation relative to weights? Were we done with that discussion?
Well, I thought we'd really honed in on weights. We have not assigned a specific weight to anything. I think in the course of our discussions, we really concluded that a weighing was a product of looking at the primary statutory objectives and the cost benefit and a number of other things, and I don't think we ever got to the precise ranking of weights to be given to the various factors, apart from that general and overall envelope. So, and I'm not really sure what additional utility going back to that and trying to assign a particular weight to various factors would be at this stage. We've really looked at this carefully and thoroughly, and we may ultimately wind up with slightly different approaches to the value and the weight of each of the things. And I think at this stage, trying to harmonize that so we come out with a single view of it would probably be impossible.
That's fair enough.
Okay. Commissioner?
I would agree.
Okay. So the next step I would ask is this. The commission, we've been at this now, I'm repeating myself, but we've been at this for quite a while. And we've gone through an enormous amount of material, and we've got two very competitive proposals in front of us. Are the commissioners now each ready to express a preference? I'm not talking about a vote. I want to have more discussion. But are the commissioners ready to express a preference about the applicants or do we need to have more discussion before we can start that? And I want to say in advance that if we're ready, I hate to do this, but I want this discussion to continue once we start it. So I would really like to find out whether we're ready to express a preference, and if we're not, talk through why not. And then if we are, I think it's appropriate to take a break so that we can come back and go through this. I know, and in a sense, I hate to do it, but I think that that's the appropriate way to approach this. Anyway, are the commissioners ready to express a preference? Commissioner Cameron?
Yes, I'm prepared to do that. I just wanted to understand your thoughts just now, which are, if we are ready, we'll take a lunch break and then come back and
Yes.
work our way through it.
Work our way through it,
Okay.
and because otherwise, it may be very quick, it may not be very quick. But I don't want to have it interrupted by this discussion interrupted by lunch. Commissioner Zuniga?
Yes.
Commissioner Stevens?
I'm comfortable with that.
No, are you ready to express a preference? That's what the issue on the table is.
It's a yes or no question, yes.
Pardon me?
Yes.
Yeah. No, those were the old days. Okay, I too am ready to express a preference. So let's take a lunch break. Let's do 40, are there places for people to eat in the vicinity?
Not very closely, so I think you need an hour.
So we need an hour. As I say, I hate to do that, but we're going to do it, and we'll be back in an hour. We'll be back at 1:25. All right, ladies and gentlemen, I'd like to call to order the afternoon portion of the 5th session of the 134th meeting, and we're prepared now to pick up where we left off with a description of the preferences that each of the commissioners has formed. And I'm going to ask, I think, Commissioner Cameron, if she would go first to announce where her preferences are. These are preferences. This is not a vote, because I want to have a little bit of discussion as to where we are, but they are expressions of a preference. So, Commissioner Cameron?
Thank you, Commissioner. Happy to go first. First, I'd like to say a little bit about each applicant, frankly, because this has been a long journey for all of us. I very much learned a lot and learned a lot about the companies on the site visits. And, you know, that was a part of this experience, and a part of my coming to a decision, frankly, is, or even having a preference at this point, was those visits. I took an opportunity to speak to lots of employees at both of those facilities. And one of the reasons this is very, very difficult is because I believe these are two strong applicants, corporate cultures, employees very much really love working at Mohegan Sun, feel part of the team. And I can say the same about Wynn. The employees feel like they are treated in a way that makes them want to be loyal to the company. So I, having spent many years in Atlantic City, I know that's not always the case with casino owners and operators. So I feel like we're fortunate to have two applicants here with strong corporate cultures. In particular, Mohegan Sun, the culture, the commitment to the environment, the commitment to the community, and the partnerships that are demonstrated, I very much value, and it's apparent in all of your dealings. With the Wynn team, you know, again, treat their employees very well, tremendous business acumen, attention to detail and guest experience, all traits that I think the Commonwealth can benefit from. So again, it does make this a little more difficult, but I thought that was important to point out that that's the experience that I came away from in dealing with the applicants and in visiting their facilities, an important piece of what we do here. In looking at everything in totality, I think we all agreed yesterday about the economic development piece, how important that is. And we're talking about the number of jobs, the salaries, and the reason for the legislation. And when I look at those numbers, I do think the WIN team has an advantage there. And that is inclusive of what a piece of this that I think is really important, and I really much value are the racing industry and those employees. That was an important piece for me to factor into this evaluation. And with those numbers, and I know there was some clarity to that today, WIN still has a slight advantage with employees, and in particular with salaries, and that is a clear. The salaries are a third higher for the WIN team, and I think good paying jobs is absolutely part of this process. With Mohegan, the site is easier to mitigate, frankly. It is a piece of this, and just the location itself makes it an easier site as far as moving people in and out. And I think there's an advantage there for the Mohegan folks with that piece of mitigation. The marketing piece I also thought was really important here, and although Mohegan has certainly strengthened their ability or their plan as far as international, drawing in international folks, I do see a clear advantage to the WIN people there too, and it's not just where those folks are coming from. It really is all the additional benefits to the Commonwealth. They stay longer. They use, they visit restaurants and events and hotels and transportation. So I looked at that as an advantage as well to the WIN folks. Both of the plans are strong. I really do give some credit to the cleanup of that environmentally contaminated site, though. I think that is a piece of this. And I look at that as an important piece here. There is some risk, though, again, we're weighing strengths versus risks, and there are some risks for the WIN team around permitting, around the ability to move this whole project forward in a timely manner. So I do look at that as something I'm concerned about. But I could mention a lot of other factors, but I'd like to hear from my colleagues. But at this point, in looking at everything, I have a slight preference for the WIN applicant at this point, after evaluating all of the factors I took a look at. So I'm going to express a slight preference for the WIN team at this point.
All right, Commissioner, thank you.
I'd be happy to go next.
All right, Commissioner Stevens?
I also, too, want to take an opportunity to thank the two applicants. When we started out on this process, now over 2 years ago, the landscape, the market looked a lot different. These are two obviously very well-recognized names in the industry, and I think obviously they're here because they understand the value of this license, and that has been proven time and time again by their commitment to their applications. I never stepped foot, as Commissioner Cameron alluded to, never stepped foot in either facility until this process started. And again, came away with very favorable impressions of the operations, of the employees, of how the employees are treated, of how the employees are respected, and the success and the feel of going into both facilities made it pretty evident as to why these two companies have been so successful. I also want to take a moment to talk about the two communities themselves, and want to express, hopefully on behalf of the commission, our thanks to both mayors as well as the residents of both communities. They have come out time and time again for a number of hearings to have their voices heard. And I know how passionate both of these communities are about this project. They're anxious for development. We talked about the opportunities, and we've been reminded about the opportunities that both of these projects have as a catalyst to further and future development. So to thank both communities for being patient with us through this process as well. When we started talking yesterday, I mentioned when we were talking about weighing the factors, the 4 factors that we were going to consider, I talked about mitigation as a factor and financing, and understanding that if you can't pay for it and you can't get to it, then the jobs and everything out the other end aren't going to happen. I think over the past day and a half, I think both applicants have, or extending in the last week, both applicants have addressed these issues, and I would expect that is to the satisfaction of my colleagues. As I look at it then, going to no knock on Commissioner McHugh's category, but if I look at the impact of economic development, which I think is really where the legislation was intended to focus, providing jobs, creating economic activity in and around the communities where these facilities are going to be located, I then began to look at reflecting back on my criteria. And as Commissioner Cameron said, and I would echo that, you know, with respect to jobs, there is certainly a clear difference in the jobs and the number of jobs, the salaries related to those jobs, both through the design and construction phase and also through the operational stage. With respect to the impact on small business, I want to acknowledge that I think both applicants have done a very thoughtful job in terms of reaching the goal that the legislation talked about, which was not to make these facilities kind of islands unto themselves. How do you have that spin-off out and beyond the community? And it's a relatively new strategy that probably other jurisdictions haven't attracted. They've focused mostly on the jobs and on the revenue. So when you take that next piece of how does the economic impact spill out beyond the property, I think both applicants had very unique, creative, and strategic suggestions to do that. And a lot of that is perspective. It's laying out a good, solid plan. Obviously, the relationship between a licensee and us goes forward. We continue to monitor that. So I took kind of a side view to it and looked at local spending is being provided by the applicants themselves. In this case, Wind stepped forward, even though both amounts were relatively the same in terms of overall operational spending. It appeared that Wind stepped forward with a more aggressive target for buying from local vendors. Finally, with respect to tourism, I think both applicants acknowledge the benefits of being in and around an international destination like the city of Boston, and certainly value all the partnerships that are already here. I think unlike MGM, which may seem to be a catalyst for tourism in Western Mass, I think both of these applicants acknowledge that there's a lot of cooperation that needs to happen to make sure that that they're drawing gamers and visitors into their respective facilities, and that leaves more money in Massachusetts, which is another intended target of the legislation. So again, on that point, I think both applications were relatively on the same playing field. I pick up on Commissioner Cameron's point when you look at the two properties themselves. Development opportunities, if I'm looking ahead, development opportunities, I think, for the Everett site are few and far between. I think as we've gone through the testimony and the host community hearings going forward, that the Everett site offers tremendous opportunities for future development. It's just kind of a outside thought or suggestion or consideration that I took into mind, but again, based on my economic development categories, I found a clear and distinct advantage for the WIN application. Again, if we know it can be paid for and you can get to it.
All right, Commissioner. Thank you, sir. Commissioner Zuniga.
Thank you. I would also emphasize what I've said before, that these were two very good proposals to very good gaming companies, as had been stated here before. There are a lot of resources that come in terms of putting an application and leading up to this point, and I'm really thankful. The Commonwealth really benefits from the participation of both and everybody that supports that operation. I've gone back recently to look at the major goals of the legislation, and I've said before, all of those goals in section 18. Many of them are competing priorities. Not one applicant is going to be able to maximize all of them, and that is the nature of the act that we had to work with. It was a great piece of legislation. It acknowledges a number of things that need to be examined, and as a result, we put together a document in the solicitation that was very extensive, and the applicants responded with thousands of pages in the response, and that was only the beginning, because there was a lot more document and information that continue to flow even after the deadline in the form of draft environmental impact reports and other things, including all the testimony that we had relative to the host community hearings and the public input meetings that we've had. But back on the 18 goals of Section 18, I will touch on some that I think, in my opinion, really make me express the preference for the WIN team because they hone in around maximizing capital investment. That is clearly something where WIN comes with an edge. Both the total amount and the hard costs, the eligible capital costs as we define them. This is almost double what we've seen from the other applicant. There's a lot of money built into their budget relative to pre-opening expenses and other activities where that flow directly into the goals that come under the umbrella of maximizing revenues and to the state as well. I've already made the point in the overall questions that fell under my section, if you will, that I think are very important and relative to capturing revenues. And the way I see this, we're building a portfolio. We are building on a decision on two decisions that we've made in the past. And this decision, in my view, the WIN team complements that a little better. They put the Commonwealth, in my opinion, in a more competitive basis. We're not the first ones to come to the gaming industry in the region. There's gaming around us. The market is getting competitive, but the one who I believe can fare better in a competitive market because they have done it elsewhere, and they also have done it consistently around them and maintain market share through the ups and downs with their segmentation and with their focus on the customer experience has been the WIN I also want to touch a little bit on the environmental cleanup, which I think was certainly talked about in the ratings when we discussed them. I remember the notion that Commissioner Stebbins advanced in that at that time relative to community enhancements, what could come around the site, if you will, which I think is a very important piece. But I also look at it in terms of the cost of not doing something, the cost of not deciding for the land in Everett may result in that land continue to sit idle like it has been for a number of years because of the level of contamination that exists, because there are very few instances, and a project of this magnitude really represents one of those instances of a development that can kick enough cash flow to be able to pay for all of that environmental remediation. So there's a lot of public good that comes out of doing something out of this site. As it was expressed before, there are alternative uses to that to the site at Suffolk Downs. There comes a cost. I'm not gonna minimize it. There are jobs that might go away, as they have stated, and will likely go away. But I think in the balance of everything else, just to my point about not one applicant is going to be able to maximize any one of these, all of these goals. That is one of the prices to pay for this decision. I also mentioned in the past the notion of having enough flexibility to react to market conditions, the competitive notion that I've stated before. My view and analysis, and the analysis of our consultants and staff relative to the financial projections, the revenue projections, the cost projections, is that the wind proposal includes margins that, in my estimation, are reasonable and could withstand what may be, changes in assumptions, changes in market conditions, etc. And there's a notion of leverage that goes alongside that. It's not exclusive. There are many other instances where costs are only estimates, but in my review of this, the wind proposal has enough comfort, if you will, to make sure that there is anticipating that not everybody will anticipate all things that could go wrong. There are enough margins in the wind proposal, in my view, to withstand downturns. I'm not saying there aren't with the other applicant, but I think the relative comparison is an important factor.
All right, Commissioner, thank you. There is much in what my three colleagues have said with which I agree, starting with the fact that we're blessed, and the Commonwealth is blessed, by the quality of the two applicants that are here today. The competition between them, the thoughtfulness that they have applied to their applications, the energy they brought, the way they've cooperated with the Commission has added great value to this process. And it is what we very much hoped would occur when we fostered and tried to foster competition in this region early on. I also want to thank both applicants and the host communities, the surrounding communities as well, but primarily the host communities for the way they've treated us, the information they've given us, the hosting they did for us when we held our meetings, and the like. And I too, in my travels to the sites, travels that were enormously important in terms of getting not only a flavor for what the vision of the site here in eastern Massachusetts could be, but also for the interpersonal relationships that abounded in the sites we visited, felt that the relationship between the companies and their employees on both sides was extraordinarily good. I don't think that I've been in two large facilities where the palpable energy of the employees not only was felt all the way down, but was recognized in such a focused way by the managerial employees, and reflected a unity of purpose and a care about the welfare of the employees that is bound to result not only in good jobs, but jobs that have a low turnover rate, jobs where stress does not predominate, and jobs where people can plan on being with one employer for a considerable period of time. I think the retention rates demonstrated by both companies are a testament to that. I look, though, and I agree in terms of the Section 18 criteria with much of what my colleagues have said. I, too, went through them a couple of times, thinking that we're getting close to the decision point. There's no question that the WIN applicant has a greater capital investment. And there is no question that it's got more construction jobs, and that the pay scale, although I was a little unhorsed by the different approach we took this morning, but overall the pay scale, the total dollars contributed to the economy through labor wages on the WIN project is higher. I gave, when I did my presentation, the nod to WIN in terms of the facility, the physical facility, a facility of high quality, although I reserve for the economic development piece the piece of that deals with partnership with local facilities. And there, I think the Mohegan Sun has demonstrated to this point a far better record and approach and outlook than WIN has done. There's no question about WIN's devotion to recapture. There are no discernible conflicts anyplace, but Mohegan Sun has now, with the revisions to the conditions, moved forward with a plan that gives a level of confidence to its willingness and ability to do that. I give to Mohegan Sun a slight edge on human resource practices. I think that Mohegan Sun's gross gaming revenues, and I think, by the way, that both applicants' gross gaming revenues are optimistic. But I do think that Mohegan Sun has a slight edge on its ability to get the gross gaming revenues that are a part of this project. I think that the quality of the jobs and the salaries for the operating jobs is better for WIN. And I think that they both have good labor relations, and they both are equivalent in other respects. I would, because of the capital investment and the economic yield, primarily through labor. I forgot to mention spending. The WIN applicant is going to spend more and spend more locally than the Mohegan Sun applicant is going to do. And that's evident if you take out some of the spending that they talked about and look at marketing, food, and beverage. The WIN applicant has much more in those three categories than the Mohegan Sun does. So I would give the WIN applicant a slight edge because of those factors. The real concern that I have, and the concern that in the end I think pushes me in a different direction, is the risk for this proposal. And I think that that's an important thing for us all to think about. It's something that I've been thinking about a great deal. We've got two very good proposals in front of us, two very good proposals. And I wonder, and my concern is, what do you do about a very good proposal that has a high risk of not being able to get off the ground? And that's where I look at the WIN proposal based on the record to date. The MEPA process has not gone smoothly. I understand the optimism that exists, but it has not gone smoothly. It's not the last step. The whole focus on the traffic mitigation that we spent so much time on in that MEPA process did not survive the final environmental impact report. And so that's out for a supplemental final environmental impact report. And I know there's confidence. Confidence has been expressed on the wind side that good things are going to happen, and maybe they will at the MEPA level. But then the Public Improvement Commission, the City of Boston, has to issue the actual permits. The actual permits to translate what the plans presented to the MEPA entity are. And those plans and those permits are essential for this process to move forward, this plan and process to move forward. I understand what the Governor Weld said this morning when he was here in his capacity as an attorney for wind. He's been around, he knows political environments, but I'm not sure that I share his optimism that once the dust settles, everything will be smooth and will be accomplished easily. Moreover, the long-range plan for the area, and I've stressed from the outset how important conformity with that plan was. The long-range plan for the Sullivan Square area hasn't been finalized. That's not Wind's fault by any stretch of the imagination. They've been at this for years. But it's an environmental circumstance that makes assessing the likelihood of success more difficult, because that plan, to the extent it's been formulated, focuses on a traffic reduction effort that is not instantly compatible, in my view, with plans to accommodate increased traffic that this facility is highly likely to draw. In terms of the environment, we look at the support for the two proposals in the community and the immediate community and the surrounding communities. And I understand the vote in Everett. You couldn't get a vote for continued statehood to pass with 86%. And so they've got an extraordinary level of support in the community. On the other hand, the support in Everett was strong. There's a strong opposition on the East Boston side. But at every host community meeting we attended, and at the early surrounding community meetings, there was not only support from the community, but there was support from surrounding communities. And there are far more surrounding communities that reached voluntary agreement with the Mohegan Sun than did with Wind. What does that mean? That means that the inevitable bumps and jolts and jerks and jolts of trying to get a significant development like this into a dense community are likely to go more smoothly and get the greater degree of cooperation that's necessary for their success in an environment where there is a collaborative energy around the ultimate outcome. And it seems to me that that is certainly present with respect to the Mohegan Sun proposal. And in Boston, in the Boston opposition, there is also the Somerville opposition. There is a surrounding community agreement with Chelsea, but the city manager of Chelsea showed up at the host community hearing in Everett to announce his support for the Mohegan Sun, in Revere to announce his support for the Mohegan Sun proposal. So the Wynn is surrounded by communities that do not have a great deal of support for their effort. Insofar as their mitigation payments are concerned, I reject the notion advanced by some that they should be required to pay the entire cost of whatever improvements are made to Sullivan Square and the immediate area. That just is something that it's a non-starter. And the improvements to their offer that they made today go a long way toward meeting the sort of skin in the game idea that I thought was essential and still think is essential for that project to succeed. There's a question as to whether or not that ultimately will be successful. But ultimately, I have a great concern about whether this project can muster the kind of collaborative energy it needs to move forward. It's going to take a while. It's going to take the cooperation of a number of interrelated entities and jurisdictions. It's going to take a solution that has some viability and some energy behind it. And it's going to take the kind of skillful, political in the best sense of the word, maneuvering and dealing and thoughtful listening and thoughtful back and forth that's essential for any of these projects to survive. I think that though I give the slight edge, and it is a slight edge, to win in terms of its potential yield to the economy and to the region, that the likelihood of its ability to succeed on schedule to produce that yield is less than the Mohegan Sun proposal, and that in the end, the ability of the Mohegan Sun proposal to get off the ground and move smoothly through the remainder of this process is greater, and for that reason, I am favoring the Mohegan Sun proposal in Revere. So I'd stop there. We've all had a chance to express a preference, and let's have a discussion about that.
Commissioner, I share many of your same concerns and have spent most of my time talking to folks about what those risks are, how, what are the likelihood of this process being held up, and came away with the slight edge, as I said, toward win because I tried to look at it long term. I mean, 50 years. And, we'll come and go, mayors will come and go, and what is the project that can endure and be the best for the Commonwealth. And trying to take that approach and really asking people who are very familiar with city government, municipal government, and the likelihood of permits being held up and how long would those challenges take, and starting with MIPA and then looking at city permits. I came away with the thought that yes, there is a likelihood to be held up in the short term, but the likelihood of success is great from what I understand, and I guess I have faith in human nature, and people want it. Once we have been thoughtful and make our decision, that people will respect it and work toward the common good for the Commonwealth. And maybe that's naive, but I came away with the slight edge in the other direction when I look at the totality of this. And I do realize the risks, and I don't want to minimize them. But the overall benefits to the Commonwealth, I still came away with a slight edge. And again, both of them are excellent proposals. This is not easy.
And just in terms of, I want to discuss, not challenge, in terms of the risk analysis, you have I sense a comfort level with the ultimate outcome that I'm having trouble with. Can you help me with this? How you look at that? I know you took a look at the long term. In the long term, this will occur. Of course, I'm not going to be here in 50 years, so somebody will have to write and let me know. But but it's the immediate short term, and it sort of gets back to the point I've raised before when we were talking about the July 1, 2015 deadline, that the specter of this process being held up for a considerable period of time while the permitting process proceeded, or conceivably, as the Metropolitan Area Planning Commission suggested, that maybe it's just a square peg in a round hole. No reflection on the application or the applicant. It's just circumstances that lead to the possibility of it really taking a long time to materialize. So I think there's a question in there someplace.
Well, I never believe that there's a problem that doesn't have a solution, first of all. And just to say it can't be fixed, to me, doesn't resonate. I do see some value in, there's already an existing problem, and this may be the opportunity to really fix the already existing problem. And, you know, I've asked direct questions about, okay, if this were to happen, how long would that process take regarding permitting, regarding, you know, MEPA process, a challenge. And I came away thinking, okay, there is a risk. And I had to decide if I thought that risk was too great or if the benefits on the other side were worth realizing. So like I said, I did spend a lot of time talking to experts and trying to find out what the real issues are here. And some of it is my belief that there will be a good faith effort to work together. And I hope that happens.
Yes, I certainly hope it happens, and nothing I've said omits the possibility or indeed the likelihood that will happen. It just is the fact that there is expressed opposition from a number of political centers at the moment, and it is a location in which a number of different jurisdictions have to cooperate and collaborate to get this done. So I understand and I'm grateful for your thoughts, but I didn't want to leave the impression that I thought that anything other than good faith would be displayed by anybody. It's just a really complicated area, site, and set of permitting regulations that have to be undertaken.
I can add to that conversation along the lines of what Commissioner Cameron is describing. I do see risks to the wind application, and they are perhaps easier to think about because they are short-term risks, just like you described. But I also see that there are other type of risks on the Mohegan application. Some of them less short-term, and I've talked about them before. They had to do with the amount of leverage. They have improved their position. They met the condition that I put forward. Comparatively, however, the wind proposal is a financially stronger capital structure, et cetera. So I share the view that these projects are large in nature and complicated in nature, and we should be thinking about this is a 15 or this is a 17-year or so, 18-year decision. You know, it's better than 15. Right. The term of the license is 15 years. It begins with the beginning of operations. So for all intents and purposes, we're making a decision for the next 17 or 18 years. And I think in terms of risks, we have to evaluate all of the ones in that term. If people recognize that we've taken that look and we have been measured, and we have been very thorough in evaluating all aspects as best we could, risks, short-term and long-term being part of them. I think people will understand our position. I also think, and I alluded to this earlier, there are factors or there are systems in place relative to those short-term goals, short-term risks, that you describe. There is a MIPA process. Yes, it's not completed, but there's, they have to submit a supplemental, and there's a process for that. There's a permitting process here. A lot of people will be watching, starting with us, and I think that's part of the environment that they have to operate in. Perhaps what you described, Commissioner, as in the end, we do believe that everybody will act in good faith. Having said that, there are the factors that I'm a little bit concerned with when it comes to the risk factors in the Mohegan application are some that we don't necessarily control. There are less, what I mentioned relative to margins, relative to assumptions they've made, whether to repay debt or not, I think, speaks to their ability to react to market conditions, again, that we cannot control, that the environment is is getting competitive. As I mentioned, we are arriving at this decision in an environment that is competitive. And I believe that for those 17 or 18 years, we need to see what applicant has the greater likelihood of an overall success, so that they can deliver on all the promises that they've made, which are the rest of all the other factors that we anyway.
No, and I appreciate that. From the merit standpoint, I too understand and appreciate those financial and other strengths. How confident are you that the MIPA process is going to end favorably? I mean, it doesn't have to. Commissioner Stebbins?
I've had, as a local economic development official, I've had some experience with the
Right.
MIPA process. And everybody in this room is familiar with all those steps, from environmental notification forms to draft environmental impact reports to supplemental environmental impact reports. It appears to me, or it would appear to me, that if our colleagues in state government were foreseeing a huge problem that could not be overcome, we'd have an understanding of it at this point. That why go to a supplemental environmental impact report if they didn't think that a cure or a solution can be found? And again, I'm not an environmental lawyer. I don't pretend to be one. And again, my MIPA experience has never been, obviously, with a project of this size and scope. The local interaction factor that you also raised and foreseen as a risk, and I hope too that parties will come to the table in a sense of goodwill, but I also think that they can be driven by a monetary motivation, that now there is a determined amount of money out there to go and fix the Sullivan Square problem. And that federal monies is I think you brought up before, that have been out there and available and on the table, will help both parties find a way to work together to find a solution, and knowing that there's a determined amount of resources to be put on the table to do that.
All right, I wish I could share that confidence. Any other thoughts that any of you have? I take it, Commissioner Stebbins, let me start with you, that your preference is a strong preference for the Wynn applicant, that a further dialogue is unlikely to change that.
Based on everything we've heard and the material that's been presented, and again, if there seems to be at least a level of confidence that transportation issues can be addressed, and the financials are now,
Excuse me a second. Yes, it is working.
the financial issues have been resolved. I value those categories, and I value them based on the priority they were given in the statute, that my preference is for the WIN application.
All right. And Commissioner Zuniga, I'm going to ask you the same question. I want to find out whether, I've sort of done the best persuasion I could, and I want to find out if there's any reason to proceed.
Yeah, no, mine is a strong preference, as you asked the question. I think if there is something really fatally flawed with the MIPA process, we would find out sooner, right? I doubt that there is. I share the optimism that there's at least a potential solution out there to something that has been a problem and is something that a lot of the region is interested in. I think part of the opposition that you describe, in my view, at least in my opinion, at least part of it, may be by people saying, how is this all going to work? What is that solution? What is that long-term solution? When does it come? And I am going to place myself in the optimist side, saying perhaps this can be a catalyst for something that has been a problem for many years and in the planning process for many years. It now comes with a number that has certainty. As I mentioned before, the applicant wanted certainty. It also benefits the region, not just the city, because those dollars can be supplemented by federal dollars if they're available. I understand that there may be, or there have been, but again, this is could get us, at least in theory, could get everybody coalescing around a potential solution, rather than saying, well, this could never work because, well, by the way, there's no funding. I think now, unlike some of the other development that has put that area in the position that we are, this is an operation that carries with it a great amount of dollars that could help and could go a long way towards it. And I think that the job we did in the last couple of days to that effect, I'm very pleased with it, with the outcome as we discussed this morning.
All right. Commissioner Cameron, same question to you.
Yeah, my preference is less clear and not as strong, frankly. I see great value in the Mohegan, what they've brought to the table. The relationships are stronger. It gives you more confidence to go with those relationships. But balancing that against the potential for the Commonwealth and, the jobs and the salaries and all of those other things we mentioned, with the process, the permitting and/or MIPA, my concern, the risk is of challenges and slowing down the process to a point where those benefits are diminished. So I really do see great risk, and which is why I am less certain about this. Because I do understand that there are avenues in which this whole thing can be held up. And, I'm hopeful that doesn't happen, and I've assessed that risk and come out with the slight favorite, the slight preference on the WIN side, because I think, in my mind, the benefits slightly outweigh the risk. And I know you come out the opposite. We're close, but
Yeah, we're
opposite.
close to the center, but on opposite sides of the line. Well, as I said, I've said what I can say. I do presume good faith on everybody's part. There's inevitably, as concerns and energies are focused on something of significant importance as this is, there are things that happen that won't happen after a decision is made, and people have to move on and work together to accomplish something. but I still am very concerned about that possibility, and concerned not only about the possibility, and I'm going to stop, that somebody doesn't live up to the high standards that we all hope everybody will, but just that the complexity of the intersecting jurisdictions and their philosophical differences about this subject and about this project will interfere with the ability to execute it in the near term. But I think that I've heard, and we've all heard, one of the things I think I also ought to say is the value of the thoughtful colleagues that we each have, and the way that we all have tried to wrestle with these ideas and think them through and come up with a answer to a very, very difficult question because of the high degree of quality on both sides. So I would ask whether the commissioners are prepared to have a vote. Commissioner
I am.
Stebbins?
Yes.
Commissioner Zuniga?
Yes.
Commissioner Cameron?
Yes.
All right, then I'm going to ask for a motion.
I can move that this commission consider the wind proposal, the proposal that better achieves the goals of this legislation, and direct staff to enter into an agreement for a award of a license in a date in the future.
Well, before we talk about that, the way we've done it before and the way I think we need to do it this time to make certain that we are at the finish line is to have a vote that awards to the successful applicant the license contingent on their agreement to all of the conditions that we outlined this morning,
Right.
and an agreement to appear before the commission tomorrow morning at the time to which we adjourn, and I know we posted it at 10 o'clock, but the time to which we adjourn, to signify orally and in writing its agreement to those conditions. I think that
That's
is the way we need to go.
So moved?
That's a good motion. I accept the amendment.
All right. Is there a second to that motion?
Second.
All in favor? Let's do this by roll call. Commissioner Stebbins, how do you vote?
Yes.
Commissioner Zuniga?
Aye, yes.
Commissioner Cameron?
Aye.
And I'm going to vote nay. So the ayes have it 3-1. The win applicant is the successful applicant. Congratulations. And we're now going to take a short recess. We're going to take a 30-minute recess, actually, and then we'll come back with a press availability. And then we will reconvene here tomorrow morning at 10 o'clock.